Welcome to the European Parliamentary Research Service podcast.
Today we'll be talking about search and rescue operations in the Mediterranean. We'll examine obligations under international and EU law, we'll compare them to what has actually been happening at sea, and we'll look at what could be improved in order to save more lives. Stay with us.
Asylum seekers and migrants all around the world have long risked their lives aboard dangerous ships in search of international protection against persecution, conflict and other threats to their life, or just seeking a better life.
And many of these stories end up in drama. Since 2016, EU action at sea has helped to save over 500,000 people in the Mediterranean. But over the last couple of years, the Mediterranean Sea has also set the scene for the largest number of casualties and missing people in the world.
In 2019 alone, almost 2,000 people died trying to cross the Mediterranean Sea, and many thousands more were never found. So why is this happening?
Let's have a look at what international law says about search and rescue operations at sea.
Under international law, ships have a clear duty to help those in distress at sea. This help must be provided regardless of the people's nationality or status or the circumstances in which they find themselves.
However, when the ships are run by non-governmental organisations and the people in distress are migrants, there are often different opinions about what is the right thing to do.
Rescue and disembarkation to a place of safety are complex operations involving different actors with specific obligations under different bodies of international law. So even when people have been rescued, problems can still arise in securing the agreement of coastal states to their disembarkation.
This is because even if the International Convention on Maritime Search and Rescue obliges states responsible for the search and rescue zone to transport rescued passengers to a safe place, there is no rule determining which country is by default responsible for receiving them, such as, for example, their state of nationality or residence, the flag state or the country where the ship departed from.
And the truth is, most EU governments are less and less keen to offer relocation spaces or protection to people who need it. Italy and Malta, for example, have repeatedly prevented NGO and other ships carrying rescued migrants from disembarking them in their port.
And the EU also toughened its stance. In early 2019, member states decided to stop the maritime patrols that had saved tens of thousands of lives in the years before, marking a clear shift of priorities from saving lives at sea to increased border surveillance and cooperation with third countries, especially Libya, to intercept and return smugglers and migrants.
This tougher EU approach, combined with poor coordination in search and rescue activities, unilateral action by certain countries, and the criminalisation of NGOs carrying out their own search and rescue operations in the Mediterranean, has resulted in migrants being forced to stay for days, often weeks, on boats waiting for authorities to decide their fate.
This has prompted heavy criticism from academics and civil society organisations who believe such an increasingly securitized approach to search and rescue at sea is in clear breach of international maritime, refugee and humanitarian law.
But what does EU law actually say about this? Keep listening.
As the European Commission hasn't failed to stress, the EU and its agencies have no mandate to conduct search and rescue operations. These are a competence of member states, so neither search and rescue nor disembarkation activities of EU member states are covered by a common EU legal framework, except when they're carried out in the context of Frontex-led joint operations at sea.
In such cases, all vessels participating in maritime border surveillance operations must respect a set of search and rescue and disembarkation obligations and are thus expected to provide technical and operational assistance to both member states and non-EU countries that require it.
This needs to be done in full respect of fundamental rights and in compliance with the principle of non-refoulement, which guarantees that no one should be returned to a country where they would face torture, cruel or degrading treatment, and other irreparable harm.
But here again, legal obligations and reality do not always correspond.
Clearly not. Some EU member states and agencies such as Frontex have been accused of pushbacks of asylum seekers and other migrants to the high seas and towards Libya, which is considered unsafe, and Turkey accused of not adhering to the non-refoulement principle.
In their defence, Italy and Malta have used the coronavirus situation to declare themselves unsafe and have criticised the European Union for not distributing the migration burden more equally among member states.
Something the European Commission tried to do in the past, but never managed to actually implement, due to strong divisions among member states on the proposed quotas system.
As regards the role of Frontex, in December 2020, members of the European Parliament's Committee on Civil Liberties, Justice and Home Affairs demanded answers from its executive director regarding the alleged involvement of Frontex staff in pushbacks of asylum seekers by the Greek border guard.
The accusation was refuted by its executive director, Fabrice Leggeri, but the EU's anti-fraud office has opened an investigation and, in what's seen as quite an unprecedented move by Brussels, the commissioner in charge of migration and home affairs has directly accused Frontex CEO of giving misleading evidence to members of the European Parliament.
The accusations are certainly serious, but what can the EU do to ensure that search and rescue operations in the Mediterranean are more effective and coherent in the future?
Well, a different application and interpretation of different bodies of international law doesn't make it easy, but one solution, according to experts, could be to harmonise laws that regulate maritime interceptions.
This could prevent states from cherry-picking provisions that allow them to justify a securitised approach to protecting their own interests and better protect the needs and rights of rescued passengers at sea.
This is a European Parliamentary Research Service podcast.
Thanks for listening.